Yes. Okay, we are streaming live on Facebook. Hello, everyone, and welcome to Family Law Fridays presented by Florida Women's Law Group. My name is Jadlyn Fleischer, and I'm a legal intern here at Florida Women's Law Group. Family Law Fridays is designed to be a resource for all women with any type of family law issue. Before we get started, here at Florida Women's Law Group, we want you to know that as the situation around coronavirus continues to evolve, we will remain open and available for you, since we have the ability to operate 100% remotely. As always, our phones are open and we are happy to have meetings with you via phone, Zoom, and are still available to communicate through email. So with that, today we'll be discussing how race can affect family law court decisions. Now, I would like to give you some information about our host, Heather Quick. She is the founder and CEO of Florida Women's Law Group, which is a family law firm that advocates for women in North Florida. The firm educates and empowers women on their rights and the law so that they end up better financially and emotionally. Heather Quick has been a licensed Florida attorney for the past 20 years, with the majority of her practice being in family law. Please join me in welcoming Heather Quick to Family Law Fridays.
Good morning, everyone, and thank you so much for joining us today. And really, as of today, we have had so much change in the past week that led us to explore some factors in regards to, really the discrimination that we see in family law cases. And of course, with all that's gone on in our country in the past, it's been going on for some time, certainly heightened recently and brought more awareness. But our focus at Florida Women's Law Group is family law. And we deal with custody, divorce, and support, time sharing, and in regards to how race affects that, of course it does. There are many issues that, come into play that we just want to discuss and, what is the law, what happens, and what are some of the maybe barriers, obstacles, things that you might see that you would want your attorney to really focus on and address. And in a lot of times when we are taking a case to court, we may or may not prevail on every issue that we want. And truthfully, it is unlikely at times to prevail on every single issue. But many times there are issues that as an experienced practitioner, a litigator, that more likely than not may come up. They're more likely than not are going to be things that are going to affect the court's decision because you've practiced in that jurisdiction. You're aware of what prior decisions by that court, maybe biases, but just a standard pattern. And it's very important. It is of the utmost important, for anybody who is, when you're represented, that your attorney not only understands that, but is perfecting the record. In this country, which, our legal system is amazing. It's flawed. There's no doubt about it. But there are many checks and balances. And in order to ensure the checks and balances, your attorney needs to understand the law and what needs to be brought in front of the judge. So they may not, in your opinion, make the right decision. They may not follow the law as it is in your state and jurisdiction. However, if your attorney understands the law, presents the evidence, and essentially creates the record, it does allow you an opportunity to appeal. And I bring that up because that is a lot of what we're going to be talking about, and that's how things change in the legal system more often than not. Yes, we have legislators that we elect, they write laws, and they pass them as, and I'm not going to get into a whole governmental case class on how that happens. But most of what really just tends to happen is those laws then need to be challenged, and are they being applied correctly by the judiciary in your case? So when we're talking family law circuit court, and that is where those are most of the cases that will then be appealed, and those are where you're dealing. Circuit is certain disputes over money that are higher than lower ones. All family law issues are circuit court. Crimes of felonies, and again, other civil disputes, for higher dollars versus a county court. So those are the cases when you believe a court misinterpreted the facts to the law, didn't apply it correctly. And of course that is, obviously that's when we end up in trial, is because we disagree. One side believes, hey, these facts support this decision based on the law. The other side disagrees. The judge is the decision maker. Sometimes they get it wrong. Sometimes they misinterpret it. Sometimes the law is just not caught up. So they are deciding the case based on what a judge ahead of them decided, which is what they have to do, without getting too technical. So, but you have to challenge it. That's the beauty of our legal system. It may take a long time, and it may be draining emotionally. However, it does work, as we see when they go not only to our state Supreme Court on decisions, but then the U.S. Supreme Court. So there is the opportunity to change, to bring awareness to things that are being misapplied. So that's where the majority of our cases that I'm going to talk about today in situations come from, because sometimes it's going to be a new situation and the courts haven't made that decision yet. They may get it right, they may get it wrong. And keep in mind, the other side, your husband, your spouse may disagree with the decision. They then have the right to appeal. So it's imperative that when you are going into a situation and you believe there's going to be issues of race, culture, religion, I'm going to get into some of that because it's not isolated. They all relate to one another, and how then that affects your case, and was the right evidence brought forth. That's what's really important, is that the right evidence is brought forth the first time. You've only got one shot. You got to do it the right way, and you need a record. You need to make sure you have laid the groundwork for a challenge later if necessary. That is something that is, we practice all the time at Florida Women's Law Group, because we're litigators. We're in trial. We are putting, you're putting your livelihood, your life in our hands to help advocate for you. But at the end of the day, there's a judge sitting there making that decision. And I believe that the judges are overall making the best decisions they can, and they are following the law. And like I said, sometimes the law has not caught up with it. Sometimes you're not represented well, and the right evidence is not brought forth to the court to get you the decision you want. That's really on your lawyer, and was there the right communication? Did they understand the issues? So when we look at the majority of the cases that we've read and some of the articles, as it talks about, whether or not there's racial discrimination, how that inequity happens within the family law arena, mostly it is going to be the cases they talk about are children. So that's what I'm going to talk about the majority of, because right now, if you're two adults divorcing and it's money, it's a business transaction. So there is, now, could that happen? It could. It is, again, I would, anything can happen, and it's important to look at what happened in your particular case. But when it's just adults and we're dealing with money, it's a business transaction. We're not dealing with as much subjective best interest of the children. That's just a subjective in and of itself, despite the fact that we have factors that we evaluate, but they must be presented to the court. So when we look at that, First, I really want to bring to light when we're talking in Florida, and of course this is throughout the country, when you look at the disparity of diversity on the bench. In Florida, 10.5% of our judges fall within a minority classification. And so that clearly is, when we have over 43% of the population in Florida, and that's based on, the last time they get the census data, is minority. So clearly it's not proportional. It is not even close to matching the diversity of our state. And that's an issue. We have only 33% of those judges are women, which I also think is a problem within our judiciary, that we don't have a balance. And therefore, they can't bring their experiences in as it relates to race, gender issues, and how that affects your decision making when they are subjective decisions. There are certainly, I'm sure, many proponents that would say, well, the law is the law, and you read it and they can interpret it no matter their race or gender. And I disagree. We all have different experiences based on how we present in this world and how we are treated in this world. And it does affect, the way you look and the way you present yourself. You have different experiences. You may have a different outlook in life. And so I do think that that is a point that has to do with, just a lack of diversity overall in our government. I'm not going to get on that at this point, but hey, there are elections coming up, get out and vote. And because if you want diversity, if you want it to trickle down and or trickle up, you got to start with a judge in a state or federal situation to get up to the top. So that is incumbent on us all to be heard on that. But I think it's important that you understand what you are, entering. I notice it and, find it very relevant to the practice, particularly of family law. We're dealing with families. And a lot of subjectivity in the decision-making of the courts. So when we talk about the best interest of the children, for those of you who have followed Family Law Fridays and have heard me talk about that's what the courts are really tasked with based on our statutes and the interpretations through the case law, that they have to evaluate what is in the best interest of the child. Now, of course, we're not, race and gender, sexual orientation, and, religion and cultural history are not enumerated in those factors. But we all know those play a part in how you raise your children and your certain beliefs. When you're going to see, from a standpoint of the family law cases that we deal with, we do not do cases that have to do with dependency or Department of Children and Families. So I am not going to touch on that type of situation, but I'm going to talk about custody issues, time sharing. Many of the cases that we read, and some are older, thankfully, but again, is that because it's not happening or people aren't creating a good record and aren't challenging? That I can't tell you, but I would imagine that as diverse as our state is in the things that go on, many things just aren't challenged, because it does take one, the right case that has the facts that line up to give you a good opportunity to succeed on appeal. So we look at what's in the best interest of the children. And when we are doing that evaluation, when you're presenting that evidence, the cases that we looked at, which are present in Florida, do deal with, when they're talking about the racial issues that were determined and what they determined unconstitutional, those were things such as an interracial marriage, one, and then what would be the determination of the child. So then they were taking race into effect, but they have to be very careful with that, because our Constitution and the Equal Protection Clause does protect you from discrimination. against race. So that inherently opens itself up for some bias as to, well, which house would the child be better more of the time. But within that, because once we're dealing with anything that has to do with race and gender, anything that falls under the Equal Protection Clause, yes, we have our Florida laws, but also our Florida Constitution, which does incorporate much of what, if all of our constitutional protections by the U.S. Supreme Court. And then if you determine that there is discrimination based on race, gender under the Equal Protection Clause, then that becomes a constitutional issue. And where they evaluate that is what's called strict scrutiny. It's quite high. And what that allows is more of an opportunity for you to prevail. And when I say it's stricter, they're looking at so you have your higher court reading and reviewing what the judge did on the lower court at a higher scrutiny, more closely. They're like, well, these are important issues. If these are some of our constitutional freedoms, these are important. We're going to look at them at a higher level, not to discount other issues that are appealable, but that is the level. It's very serious from our standpoint of our constitutional protection. So again, if there is such an issue, and many times what we also found in the case law was not maybe during the initial divorce as much. Sometimes you'll see that it is a post-divorce. And then we have a situation where after the divorce, the wife married, it was an interracial, biracial marriage, a subsequent. Now you have, say, the father challenging the mother challenging the father on, hey, this new circumstance, because now it involves race. So that's where you're going to see those types of things, is how there may be a change, it relates to it. Because if everybody is of the same race, could the court discriminate against you? Yes. And that's why I said we're not talking dependency and those types of issues, but where we see it in our arena as it relates to custody and time sharing, that's where we see more of the potential for discrimination, the potential for preserving your record, because now it brings it up. What is that judge's experience? We know if you're not within the 10% of the minority court, that you may not have that opportunity for somebody just to bring a different perspective. And therefore, that could be an obstacle. And I'm not saying it is for sure. I'm bringing awareness to this, that we should all be aware of it, and we should all be looking out for our clients and looking for if we see that as a potential issue. Now, when you're dealing with issues of modification of time sharing and custody, and I say custody because that is really the common vernacular, but within the Florida courts and within our law, it's considered time sharing. You're sharing the time with your child. Nobody has one over the other. But just for clarification on that. But when we look at that, we also look at parental responsibility. And this is where I have seen this issue more come up. And it does have to do with the cultural differences, which can also, be racial. It's not, they're really not mutually exclusive. And that has to do with religion and medical care, mostly religion, which of course, as you know, we have our constitutional protections within that. And it is can get very litigious. So we have two folks who are divorced. Maybe they're married, had different cultural, racial, religious backgrounds. Then after the divorce, we have issues of how they're going, the religious issues, but also that can fall into schooling. And that's where it gets a little gray. And then the question becomes, is the court commenting on religion, or are they commenting on culture, or is it race? I think they all bleed together, and it's a very slippery slope. Most of the courts don't want to touch it, but they have to if you bring it before them, and they have to make a decision because a child's best interest is at risk. And that's where you need to at least be aware that those are issues that the court may have to decide. And I think it really does, it goes beyond just somebody, being Catholic versus Baptist. That is both Protestant, but more so when we look at, Jewish schooling, Jewish training versus Christian, the Muslim faith versus Christian, and how those get balanced, and how, if the parents can't decide, but it's a decision that needs to be made for the child, how that happens and where that discrimination is, and how you, one, preserve your record and really prove a case that then, potentially you could get reverse on appeal if it doesn't go your way, or also being aware, if you do prevail, have you made sure you had enough of a good case so that your ex-husband doesn't appeal on that issue. And that also deals with medical care. Many, religious beliefs, cultural and racial backgrounds have certain beliefs in the way medical care, should be done, what should be, considered and allowed. And what we have in Florida is what's called shared parental responsibility, which means you're supposed to work together on those issues. But what if you can't, because they are so diverse? On the issue of medical care, that is going to be the best interest of the child. There's a lot of case law on that, despite maybe religious beliefs that science doesn't uphold, because the child's a minor. And there is quite a bit of case law on certain issues as it regards to that. But I think that we will see more. I've certainly seen and had to advocate, and we've litigated cases that really had very different cultural, religious, racial issues that needed to be decided, because if you look at the way the schooling is, and I can only speak for Florida and the public school, but it is, the calendar is very much based on the Christian holidays, and that puts somebody of a different cultural, racial background at a disadvantage from a standpoint of their children. And what if they want to celebrate different holidays and they're not addressed at all? I tell you, they're not addressed at all in the standard parenting plans within Florida. That's an issue. I would say, just on its own, the fact that it doesn't even address it or make allowances for it could be considered some type of discrimination, but you have to raise it. If you don't raise it and don't present it during your case, well, then it wasn't brought as an issue to the court. So a lot of what we may see within the family law arena requires good advocacy, good representation from the beginning, because you know better than anyone the issues that you are facing, that you believe your child, the way you want your child raised, and just as well as anybody else, the differences your spouse may have. And those differences may come up later. People convert religions, they marry someone of another race, another culture, and then bring that in with their child. And it does affect your children and how things get decided. And if you are unable to agree to that and come up with, a compromise with your spouse, your ex-spouse, that's going to be an issue the court's going to have to decide, and they're going to have a hard time with it. They are really going to need evidence and facts that are going to help them make a decision for the best interest of the child. And at the end of the day, it is best if the two parents can make a compromised decision, because it's a difficult decision for the court to make, and they run the risk of violating your constitutional rights in equal protection, and then you you end up really with a decision probably no one's happy with, or one person versus another. But then, is that really best for your child? And we deal with the constitutional issues, and that has happened in Florida there, and it's been quite some time, certainly probably more than 15 years ago. It could be longer, but I feel like it was right around 15 years, 10, 15 years ago, where it became clear that grandparents have no rights in Florida over, their grandchild, because you have a constitutional right as the parent to raise your child without interference. So those rights as a parent are very high up in regards to the court system. And your rights are there, but then also the best interest of the child. So they have to be balanced. And it is also important, though, that, we look at areas where there is the potential for not only discrimination, but maybe even it's at the end of the day, it is, discrimination, but also misinterpretation. And, we'll see it. We don't deal specifically with a lot of adoption. There is a lot of case law on that, those are issues. And certainly, if there was a problem with that, with trying to get an adoption, because that's very regulated by the state, but then you bring into any discrimination, those are things that we, as our office doesn't deal with, but they're certainly prevalent and important. And or if you have adopted a child that is of a different race, and then you're divorcing, how does the court handle that? Are they accurately taking that into account with a sensitivity, with really knowledge? Because there's going to be knowledge that's required of a judge to make the right decision on behalf of a child. And frankly, I never recommend relying on the court's inherent knowledges and experiences, because I guarantee they're different from yours. Just like your attorneys, you need to present evidence. You need people there in the courtroom on your behalf, on behalf of your child, who have experience and authority to educate the court on how it will affect your child. And again, that's all part of making a record, part of creating a situation where, one, you're hopefully preventing any type of discrimination or infringement on your constitutional rights as well as your child. But again, it's allowing the court to hear it. And then if they make a different decision, then it's more clear. But if you haven't provided anything but your beliefs, your husband's beliefs, what you think is best, which I'm not saying that's important, but it may not carry the day for you if you're believing that there are more than that. As we enter this time of heightened awareness and sensitivity, more issues that are really becoming up, and it's been happening, I think, for quite some time. And hopefully that the peaceful protest, the awareness is going to have an effect on how the courts handle these decisions, and they make decisions. But at the end of the day, you need to understand how it affects you, and finding a lawyer who does understand that, so that you are being advocated for. It's and that can be difficult, because as a non-attorney, you may not know everything that needs to be presented. And so at Florida Women's Law Group, we certainly are very cognizant of issues that are affecting everyone these days, and how that plays out in your case. We And I'm not going to go much further into the issues of domestic violence and injunctions, but I think that's where you potentially could see a lot more potential discrimination based on race that you need good advocacy. You need to look out for yourself as well and seek out representation that is making sure you're advocated for and not just assumed to be in one camp or the other. And that is because I know it's still, we still see a lot more discrimination within the criminal courts. I think it's much better than it had been in the past, but I think it's still there. And when we deal with domestic violence injunctions, it's just, even though it's a civil issue, many times there are criminal cases attached. And so therefore, if race is a factor, you should be looking at that, and you should be questioning, are you being protected? Are you advancing the correct case so that one, you're protecting, you're setting a good record for appeal, but also providing enough evidence for the court that they aren't potentially making a bad decision that is not based on the facts and the law and is bringing in some subjectivity that does lend itself to mistakes. And that's why we do have the appellate system. I hope this was helpful. It's not an issue I think that has been discussed a lot when we're talking within the family law arena and divorce and custody, but I think it is important that we continue to discuss it and we have those conversations, because if you see discrimination in one area, it's going to be throughout. I usually don't think it's limited, particularly if it's within a sector of a court in an area, or just, within, police departments. Sometimes it may be just one person, but it can affect other areas, and it's important to shed a light on it because our court system does allow for that. So if you, have experienced that, or, have any insight or comments, we'd really love to hear that. I think that it's a conversation that will continue, and is important that we are, really looking at those types of factors when we have a case, and how do we do our best to prevent that and make sure that, everyone is, we are treated equally under the law. And that's difficult. It doesn't always happen. And it does require good representation. It's not something that is, that's not a given. Certainly in the family law arena, you do have to have the representation and the record and the evidence that is going to get you where you want to be. And of course, that is our goal for all of our clients and all of you watching today, that if you are struggling with really any legal issue that you need our help or another professional's help, our goal is to get you, from where you are now, and help you solve your problem and get to the other side. And please reach out. JD will give you the information that you need to do so. And I thank you for watching, sharing this video with anyone who may be interested, and I hope it was helpful for you today. Thank you so much.
Heather, thank you so much for addressing such a relevant topic today. And thank you to everyone who was able to listen in for Family Law Fridays. As always, like she said, if there is a topic you would like addressed or a question you would like answered, please call, email, or send us a Facebook message, and it could be addressed in an upcoming video. Additionally, like I mentioned before, if you are contemplating divorce, looking at a modification, or need help with your parenting plan or time sharing in this uncertain time, please reach out to our office, as we are here for you. We're available by phone at 904-241-0012. We hope you found the information today helpful. Thank you, and see you next time.